Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Those of you joining us live this afternoon have the opportunity to ask questions and interact with our speaker, and I encourage you to do that. If you have a question, please type it into the comments section below this video, and we'll be sure to address it. Episodes are released each week following the live broadcast, however, so be sure to hit that subscribe button and click the alerts icon to make sure you don't miss an episode. Today, we have Kari Jones with us. She is back. She has been with us before, and we enjoyed her so much. We brought her back. And if you recall, she's out of Denver, Colorado. She's going to be talking with us about the Women's Summit. And I have a lot to learn about the Women's Summit. I even asked her a few questions before we got started because I didn't know as much about the history of this college course as I thought. And as you all probably know, Kari practices personal injury as well as being on KTI faculty. We'll put her contact information in the description below this video as a reminder so that you can contact her if you have questions about this program, the Women's Summit, or anything else. So Kari, tell us about the Women's Summit. And actually, let's start with the inception. Where did it come from? Why and how and all of that good stuff?
You got it. Jenna, thanks so much. It's good to be back. Good to see you. I had to go back and do a deep dive because I don't know if you feel this way or if anybody else feels this way, but since COVID happened, I feel like anything pre-COVID happened like 20 years ago. Like it's almost like I have zero memory of before 2020. So in 2018, Mr. Keenan got a group of female edge lawyers together. I want to say it was roughly 15 to 20 of us, and he brought us to Houston, and I don't think we really knew exactly what was going to be happening, which is true to form with Mr. Keenan. So, but we knew something was brewing. And we got together and we spent a day and a half to 2 days in a hotel conference room, essentially coming up with what would inevitably be the curriculum for a Women's Summit course. And I distinctly remember Mr. Keenan telling us, if there's one thing that I've learned, it's that a female trial lawyer can be the most powerful lawyer in a courtroom. And he wanted to harness or tap that energy and develop a course to help other female edge lawyers recognize the power that they already had. And so I remember being in a conference room with a group of women that I was just in awe of. I mean, we have Laura Joyce, Marjorie Huff, Alexa, just to name a few. And I hate not naming everybody, but I was in awe of the talent that I was surrounded by. But we just came up with a course that we knew was going to be a work in progress because we too wanted to learn from other women that would come to the course. So we knew there was something powerful. We just wanted to develop a course that would help educate other women, but also educate ourselves on, essentially the power that we all have. That's where it started.
All right, that's fascinating. I kind of was thinking, and I think Youngji and I both were thinking that this was just a seminar or something where you went in and just talked about how hard it is being a female lawyer and blah, blah, blah. And we were like, I just don't want to be involved in something that's just like perpetuating the negativity. And I mean, we already feel that kind of as we step into the courtroom a little bit. Judges don't look at you the same way, and jurors make really terrible comments about your fingernail polish color or strange stuff that,
So true.
So it's not like that at all.
Yeah, no. So we wanted it to be the opposite. Well, we didn't want it to be with a session, like a complaining session for a group of women. We wanted it to actually be a course, and the course, we taught the course for 2 years up until COVID, and had quite great attendance for the course. So we did actually hold the course for those 2 years, and just sort of where it stands right now, and we can certainly come back to this, but the idea was in COVID, so So Laura Joyce is the dean, and Sherry Biscolo and I were the co-deans. And we wanted to, after teaching the course for 2 years, we wanted to conduct some more focus groups. And so I'm sure you're going to be shocked to hear that part of the Women's Summit course was showing some focus groups that Mr. Keenan had done that I think prompted the course, because they're pretty fascinating. So having taught the course for 2 years, we knew that there were more focus groups that we wanted to do to show the attendees. And so it's kind of been stagnant for the last couple of years. The goal is that we're going to regroup. I know I just talked with Laura about the course, and our plan is to regroup at the beginning of 2023 and hope to get it on the calendar again.
Oh, good. Well, I'm excited. I'm all for that. So that's really cool. So the focus groups, if anybody has been to an EDGE course before, there's always a portion of it where they show a focus group that Papa Don has done. And so you kind of watch and you learn a ton from it, not just from the feedback that the attendees give, but also from the presentation and the questions Papa Don asks and that sort of thing. So they're really, really interesting. So is that the sort of focus groups he's doing, Kari, or is he doing focus groups of potential attendees of the college to find out what they want?
Great question. So what Mr. Keenan had done is, before we even came together, he had done focus groups, and the topic was, what is on Bubba's radar when they think of a female plaintiff lawyer? Like, what do they think about us? And I know that the women that are listening are going to be super shocked to hear this, and I'm kidding, but we're held to a different standard. What? What? We have to work hard. We have to work harder? I know, we're all shocked, but that's really what was on Bubba's forefront was, gosh, we hold them to an almost unattainable standard. And so here's the shift in my mindset that was like an aha moment. It is not about what I thought I needed to be, although you always have to be authentic. But what we all know from focus groups is not what we think, it's what Bubba thinks. And so the course was really, in my opinion, what it revolved around was recognizing the standard that you're held to and working with it, right? Because we all know what happens when we ignore what the focus groups are telling us. Bad things happen.
Yeah.
And so there is a series of focus groups that are so fascinating, whether it's about a female trial lawyer's attitude, which was like mind-blowing.
That's a big one. That's a big one.
Right? What they thought, like the word shrill.
Oh.
That's the topic of, yeah, it's fascinating. Our dress, no surprise. The expectations, all types of things. How we handle witnesses, what our role should be. I mean, all types of topics. So it's incredibly fascinating. So of course, a huge part of the course is watching the focus groups and just kind of hoping we can open attendees' eyes that, look, you may have your own view about how you should present, but you better darn well listen to what Bubba thinks at the same time.
Yeah, that's super helpful. I'm just thinking back to a couple of focus groups I've done recently, just not on this topic, but just presenting things, and the comments that I've gotten from focus groups and from jurors about, well, you were too passionate in this area and you should have been more passionate over there. And I'm like, well, and I don't hear, and I one thing about me personally, I really don't like to say, oh, I have it harder because I happen to be born a woman. I don't like it. There are realities, however, that, just because of society and norms, and these are totally things that people oftentimes don't even think about. There are certain realities that even folks like me who I don't even want to think about things like that, have to acknowledge. And that's one of them is how, somehow, even though I think we have more women in the profession of law than men, or at least more women are going to law school. I know there's that statistic out there, but even though that's the case, there is still a certain image of a lawyer in people's minds from, even though, there's The Good Wife and all these other powerful women lawyers out there on TV, for whatever reason, there's this image people have, and that we have to uncover that, because it affects our clients, because it affects the way that focus group or that jury sees you, feels about you, thinks about you, and they cannot separate it. They cannot.
100%. And you're spot on. And I want to be clear too. I mean, you bring up a really good point. It is, I am with you because I hate this idea that my chant or my rant is not, I have it so much harder for me. My rant and my chant is, I have a power that you then don't. And that's the whole point of this course. And that's what Mr. Keenan was trying to bring to the forefront here is like, my God, when you tap this as a female lawyer, that's not even something Mr. Keenan can do.
Mm-hmm.
And so we have the ability to present a story to a jury in a way as women that I think men can't. And it's not about better, right? Because men can do things too in a way that we can't. But it's about just tapping the resource that we already have as women. And I think a huge part of that is just being a teacher, a storyteller, recognizing the perceptions, though we may not like them, but recognizing what the perceptions are and fitting into the mindset of the juror so that they receive what we're telling them. And I want to tell you something too that's happened since we came up with the curriculum for the Women's Summit. And this is a big part of why we wanted to do more focus groups. I tried a case in April, and it was against a female insurance defense lawyer. And I will tell you, she's probably one of the most obstructive defense lawyers that I've ever had in trial. And here was my opinion. I thought the jury was going to absolutely despise her. I was wrong. And in the feedback that we got from the jury, do you see this too?
Yeah.
And we're like, what did you think about her behavior? And their comment was overwhelmingly was, well, she's doing her job.
100%. I'm so glad to hear you say that because in my last trial in April as well, they were like, you looked like you didn't know what you were doing because you didn't object. And I'm like, we've been taught not to object and like let the evidence come out. And so now I'm being punished for that. I didn't think of it being a gender issue at all. But again, like when you're with two women like that, 100%. Yeah. The dominant, more forceful, objecting person, at least in my experience, and it sounds like in yours, wins. Yeah. So this is why we wanted to do, Laura and Sherry and I wanted to do more focus groups because in the 2 years that we were doing the Women's Summit, what the focus groups were telling us that we were showing them were one thing, but we also had our experience from feedback and trials. And so we knew that we needed to do more focus groups to really kind of pinpoint what Bubba is saying. But that, I think that, two things too, I think that the expectation of a female defense lawyer versus a female plaintiff's lawyer can even be nuanced and different as well. So those are some of the things that are on our radar as instructors to continue to focus groups so that we can present it and debut that when the course finally opens up again. But you're spot on. I mean, and so it's kind of like finding, this is where the authenticity comes in, because I think no matter the gender, anytime you suppress who you really are, that's never a good thing, but it's about maybe tweaking it in a way that the jury can actually hear you. But so that was a big eye opener for me, and even with the same gender, there's that double standard between plaintiff and defense lawyer. But no surprise, and you brought this up earlier with the nail polish. Yeah. So the focus groups on the way that we should be dressing and the messages that are sent by certain things, there's this really fine line, because if we have clothes or even a bag that isn't nice enough, then perhaps we aren't very good. Yep. Yeah. Which is terrifying. And then but we can't be too provocative. Right? And that's a fine line. And what does provocative mean? Well, could mean the nail polish that you choose to wear at the height of your heel. You know, how tight your suit is. One of the big discussions that we had when we were putting together the curriculum is there were some women, and I was so fascinated and intrigued by it, that they were like, we don't wear suits.
we'll do a dress and a sweater, because that's like, I feel like I can connect the best with jurors. Now that's something that men can't, I would imagine, can't get it. They can't show up in a, I don't know, a cardigan like Mr. Rogers.
Yeah.
But probably we can, right? And get it, you know, it's about finding what your comfort zone is. And there was a lot of discussion about that, and whether that's almost a uniform, because would my preference be to wear like a badass suit every day, all day? Absolutely. But am I willing to tweak that so that a jury can look at me and actually hear me? 100%. Mm-hmm. But again, it's about finding your own style. Another big piece of the focus groups that we talk to the attendees of the course about is focus grouping you. Mm-hmm. How is it perceived when you give your closing argument dressed differently, or your tone is different? Or I really believe in having a trial partner that is opposite gender, depending on the case. That may be something that you want to really think about if it fits for a particular case. So if you have somebody that's the opposite gender that's your trial partner, then focus group the two of you, you know, giving an opening or closing argument. How is it perceived? Most importantly, though, I think that what is super important is focus grouping a really important direct or cross-examination, because here's where it can get interesting, because we all know that with cross-examination, there's a tendency to want to go hard, and we all know what a soft cross is. Well, I think it's really important, if it's an important witness, to focus group. If you and only you are going to be doing the cross, see how it's perceived if you go hard, and if it's ever going to be acceptable, because then you're the quote bitch, right? And maybe that's a turn off. I hate to say it, but it's something we have to consider, right? So these are all things that we talk about in the course. It's just really being mindful of it in terms of your strategy.
That's interesting. And for folks who are listening, you know, I think maybe we might think of things like, you know, if somebody's commenting on how you're dressed, they want you to wear a dress instead of pants or whatever. You might be thinking, well, maybe it's a more conservative jurisdiction. But both Kari and I are in not very conservative jurisdictions politically. I'm talking politically, really. Right. And we're seeing and experiencing the same thing. So I don't want people to come away from this thinking, well, that's just because you're down in the South mm-hmm. or, you know, whatever. This is across the board where we did a focus group. Again, this was a while ago, though. This was early on when Young-Ji and I were first starting to work together, and we did a focus group on a sexual harassment case. Mm. And I'll never forget, I had a skirt that went down to my calves, and I had heels, and it was hot. It was hot summer, and I had a wide tank top. So it wasn't really a tank top. It was like a sleeveless shirt more than anything. And then Young-Ji had red nails. So this is where this comes up. But they lit into us. They said, well, you're wearing heels, and this is a sexual harassment case. We can see your shoulders, and this is a sexual harassment case. By the way, you shouldn't wear red nail polish. Ooh. By the way, stuff that, I mean, we asked about how we presented, thinking they would say, well, you need to, you know, project your voice more, or we were asking for like feedback on the content, as well as ourselves, but did not expect that sort of thing. And I, from personal experience, I have spent so much agonizing time over whether I should bring a bag that's expensive or not so expensive. If it's too expensive, am I going to turn off the jury thinking I'm, you know, better than I am? If it's not expensive enough, do I seem like I didn't, you know, win enough cases? Is that a good thing? Because then they'll feel bad for me. Is it, you know, it's totally stuff that's beyond just preparing for your trial, which is already so stressful.
All the things, it messes with your head. Mm-hmm. It's just, this is why we don't sleep when it comes to trial, because these are also the things that you're thinking of. And I'll tell you, this last trial that I had, you'll love this. To your point, the jury also said to us, well, we knew you took the case seriously because you really dressed up. Okay, and then this is the kicker. Your shoes matched your belt. And I wanted to take my purse and just chuck it across the room. I'm like, hold on. You were focused on my belt I didn't even think you could see my belt. Like all the things that you're not even like cognizant of. You're thinking that they're so focused on what you're saying. But I will say this too. So I can't remember if I talked about this in the last time I did the podcast, but I was on a jury in 2019 in a criminal case. And that trial was just shy of 2 weeks. And because you have nothing else to do but just sit and stare and listen, I get why the mind wanders and you start to focus on other things. And so that was a wake-up call for me just into what it must be like to sit there and hear the same things like over and over and over again. So side note that's kind of, on point for all, whatever the topic, is that I got to the point in being a juror that I was like, all right, I mean, the things that we as lawyers think that we need to hammer, just pump the brakes a little bit, because the jury at the end is like, I get it. If I hear that one more time, I'm done. So there's that. But now, to some extent, I can understand why the focus is on the small things, because it's a lot to focus that intensely for a period of time. Mm-hmm. Fascinating, but also really hard as a lawyer when you just leave nothing. There's nothing left to give, and you're so exhausted. And then to hear that's the thing that they come up with when you have the opportunity to talk with them, you're just sort of at a loss. But hey, we have to recognize it, right?
We have to. And
it is what it is.
The reality of it. And I mean, I'd love to hear from some men too, if they've heard things from people, because I know even though you technically have a uniform that you wear every day, you wear a suit. I don't know if you've been told maybe, oh, your suit's too pressed, or it's a little bit wrinkled, or if, your shoes didn't match your belt, or, maybe jurors make these comments to men as well. It would be really interesting to hear that.
Same here. And I also wonder too, this is something that I've been interested in. I've talked to a very good friend of mine. I practice with her, and she exclusively does criminal defense. Mm-hmm. And so she gets away with things that are a little more saucy. I'm going to call them saucy, because she wears the really super high heels. Oh. And so I'm wondering, can you get away with different things in doing criminal defense? Because maybe, right? Because there has got to be something that's so unique, just in terms of the tight square that we have to fit in as a female plaintiff lawyer, because we're asking for money.
Yes.
Right? And maybe that's the link too. And hence the reason that we need to do continued focus groups on this topic. But yeah, I would be interested too to hear from men. I'm always fascinated if they have any of the same experiences. And if so, how they handle it, or if they've shifted the way that they dress in any way, or, even what car you drive to trial too. That's a consideration, especially if you're in a rural venue. And, you don't want to be rolling up in some, fancy, obnoxiously bright colored, sports car or something. These are all
yellow Lambo at home.
Okay, that's right. Leave it. I mean, that's what I do, Jenna.
See, I know, and the people, Kari. You speak to the people, the language of the people.
Just a woman of the people. When I'm driving a sports car, just kidding. But no, and a little further insight into the course too, just in terms of structure, we developed something that's really cool called our Bill of Rights. Which I think women would really like. And it's just sort of we talk about, expectations and rights for our clients, right? And especially in direct exam. And this is ours as lawyers, which is super cool. Yeah. And it was really fun to come up with that, and empowering to talk about what we demand of ourselves and, most importantly, others. Just in our practice, because it's not just about trial. The course is not just about trial. It's just about living your life, navigating in a tough industry.
That's a good point. Do you teach about how to interact with opposing counsel or judges as a woman? Yeah.
As you would imagine, for any of you that have taken an EDGE course, we talk a lot about POV. And there's a huge chunk of the course where we're talking about the point of view of opposing counsel, whether it's male or female. And really importantly, your judge. I know in my last trial, again, is a really good example. We had a female judge who was new to the bench. And in her POV, my mindset was, this is scary. And she's having to prove herself. I think we were maybe the second trial that she'd had on the bench. And so, just no matter the gender, but being mindful of, a POV can be, if not one of the most important things, but at least should be an important thing in any case. But just in terms of my interactions with her, I mean, we were about the same vintage. And so being like small things, but just like being cognizant of making sure that I really gave her deference as a way of giving her confidence, because she didn't come out of the gate like, I'm going to tell you all what's up because I'm insecure and need to assert my authority. That was not her jam, which I really respected. She was very much like, help educate me in a vulnerable way. So matching that with really giving deference to her in a way to show confidence, just these little things that opposing counsel, a real big one. I was thinking about this morning on my drive-in, but we had a younger female attorney in our office, and she was defending the deposition of one of our experts, and opposing counsel was a significantly more experienced older man. And she had emailed me during the depo and asked if she'd done something wrong because she had objected, and he came back at her and said that's improper and kind of gave her pardon my French, a bunch of bullshit. And that was an absolute red flag to me that he's testing her, because she looks like a baby. I mean, she just kind of has a baby face, and so, but very wicked smart, as they say, wicked smart. But I was like, take a break, let's have a conversation, and just, pumping her. I think as women, we've all been, and there's a difference. I'm just going to put this out there. Like it or not, there is a different dynamic that is so unique when you're a younger female lawyer with an older male opposing counsel. And we all, as women, we've all been there. We've all been in the room. And there are two kinds, typically. One is super respectful and almost gives you deference because they know that you're probably nervous. Mm-hmm. And then there's the other kind that our awesome lawyer experienced yesterday and tried to take advantage. And so, in talking to her and understanding, because I've been in her POV, just reassuring her and saying, stick to your guns. He is he's testing you, unfortunately, but he will back off. And lo and behold, that's what happened. And out of that circumstance, what did she get? She got confidence. Mm-hmm. Like, I can do this. I don't need anybody else, because I was like, I am happy to whoop into that Zoom and just give him a stink eye. Mm-hmm. But I don't want to do that because you've got this. You don't need me to save you. You have yourself.
Right.
So anyway, that was kind of, I could tell, like, that was a cool moment for her to realize, I can freaking do this. And I'll tell you what, side note, early, I was introduced to Reptile/Edge at the very beginning of my career, which I was super lucky.
Yeah.
I know you feel this, like when you figure that out from the beginning, it makes life easier. But I, 100%, one of my very first depos, I had just come out of the deposition seminar, and opposing counsel was, of course, I'm exaggerating, like 90 years old. Been doing this way too long. One of the
gotta get out of the game, buddy. Let it go.
I mean, just condescending as all get out. And I started to take the deposition of his client, and I touched a nerve, and I walked out of that deposition with so much confidence. So I really do credit the Edge, especially as a younger lawyer, just with the confidence tools. Anyway, that's, an aside.
Yeah, absolutely. I will say one thing that the reason that is because Edge teaches you to know the law, know why you're doing what you're doing, know that the questions you're asking are backed up by either evidence or, what do they call it? The good faith belief it will lead to admissible evidence, whatever. You know that. So when somebody on the other side is telling you you're doing it wrong or whatever, you have the confidence because we've all been taught through this organization to be ready for that sort of a thing and, anticipate it and whatever. And Yeah, I mean, I agree with you that I got into it early enough in my career that have been, but it's still hard. It's still hard. I had an older defense lawyer tell me one time that I wasn't asking very artful questions, and he was right. I was not asking artful questions, but I looked at him and I said, I'm not here to ask artful questions. I'm here to get information from your client. So
Boom.
let's keep going. And because I was terrified. It was a 30B6 deposition. I was there by myself. It was a multinational corporation. And I was probably 27, 28 years old, maybe. So I was like, really early in my career, and I wasn't sure if I was doing it right. But and actually, I think this was after we had gotten into the edge. So absolutely, I echo that. Because I was like, nope, I know my question isn't perfect and it's long and rambly, but I'm asking the right things, and we just need to be patient, and I'll get there because you're doing the right thing.
I love that was your response too.
Yeah, I said, I'm going to ask our questions.
Totally, which is also like, I don't give a shit what you think of my questions. I'm going to get what I need from your client. So just, you know where to go.
Yeah.
No, the confidence thing is a big deal. And that's really a part of this course too. And it's not about, I want to make this clear too. It's not about, men, you're not included. But let me tell you what is important about it. And that is, as you can imagine, there are women that are attending that want to feel like they have a safe place to talk about things just with other women. That was definitely something that came out of this course, is that we had from various vintages, right? So women that were just beginning their practice to women that had been practicing for a very long time. But it wasn't about, a bunch of stories where everybody's complaining. It's about sharing, like, there's sort of this uniformity in terms of everybody experiencing the same things, just on various levels. And there's something that's really cathartic about that too. But it's the exchanging of those stories, I think, really helps other women, because I'll tell you what, there have been times, even since teaching that course, where I remember back to stories that I've heard from other women that really, in my darkest moments where I'm feeling like I am not good enough, I listen to those, I remember those, and that's honestly and truly what helps me get through. So that there is that piece of the course, or I hope that women get from the course, that they walk away and they feel like they have a whole nother community, so to speak.
Yeah, there's actually a woman, Karen Kohler, who's in trial right now in front of a judge who I was in trial in front of with Young G in July. And he's one of our better judges in King County. We have a really difficult bench in King County for plaintiffs' lawyers, but he was just difficult and mean and condescending, and he just got worse throughout the trial. And Karen is this magnificent trial lawyer. People who are listening probably know who she is, and she's in trial in front of him. And I've been hearing stories from her that she's experiencing the same thing. So and it's not that I'm happy that he's being mean to her or yelling at her about witnesses or anything like that, but it's like, okay, it's not just me. It's not something I did wrong. And I think, to your point, Kari, that's the sort of environment that can be helpful in a course like this, where it's like, yes, I've been there. You didn't do anything wrong. You're not a bad person. You're not a bad lawyer. You didn't let your client down. This is something we're all 100%. Experiencing.
100%. And to that end, another, sort of takeaway from the focus groups that Mr. Keenan did in anticipation of this course, one huge takeaway was that a female plaintiff lawyer, the expectation is that they be better than everybody else. Because to be subpar means to be, like, literally have the ultimate discredit. Right? So they're
perceived as subpar. Like, if the defense is objecting and you have a judge who's completely clueless, and that judge is sustaining those objections, even if they're wrong, the jury thinks you don't know what you're doing. They think you're wrong. So they look at that as incompetence. So you have to figure out how to navigate those waters.
Such a good point. Like, such a good point. And that's why it's even, and look, I'm not saying our job is harder than anybody else's, but my point is that the expectation of a jury when we walk into the room as a female plaintiff lawyer is that we have it all together. And the reality is that you can never have it all together. That's not the way trials work. I mean, I ended up settling a case 2 weeks ago, the Friday before trial, and I was talking to one of our younger lawyers who was going to help me try it, and I could tell she was scared. And I just looked at her and I said, I'm going to tell you a little bit of secret. Shit's going to go wrong. And this is your look when something really terrible happens. You just go. Mm-hmm. You don't let it up. You don't show it on your face. You just expect. You just nod your head like, yes, I knew this was going to happen. I knew that we were going to go down in a blaze of glory. But because you can't, nobody can control. But that's just a part of the added pressure in that. I think from a juror's perspective, when we walk in, we have to remain calm. We have to keep it together because the standard is elevated, and it isn't. We have to recognize it, and it is what it is. Mm-hmm. I think though that just like anything else in this world, having the information, having the knowledge going into it, just makes us all the better. We can't ignore it. Is the bottom line.
Is it something that the course teaches or that you found is helpful to address with a jury? You know, I don't exactly know. That question just popped into my mind. I don't know if you'd say, hey, I'm a woman, do you have a problem with that? Not like that, but more, I don't know, is there a way to address it to say, you know, kind of how Papa Don does sometimes where he communicates with the jury by either mispronouncing something or doing something silly.
I've seen it.
You know, yeah. I mean, is there something that we can do to try to say, I'm sorry, I'm working with what I've got here. I'm sorry, I'm not Annalise Keating from How to Get Away with Murder, who's like fabulous, and I don't know.
I think so that's interesting. That's a really good point. I think that comes down to, you know, like anything else in our cases, but in jury selection and finding those ways to insert really what you're testing in whatever question you're asking to get the feedback, because here's what you're looking for. I don't know about you, but you're looking for warmth, like whether it's a smile or a nod or you know, whatever it is. And that, and I don't know if that answers your question, but finding questions to ask even in jury selection to see if they're with you in a way, whether it's like inserting humor or something that's just you. Mm-hmm. To see if they're willing to lob onto it so that you can say, okay, good, I can take them with me through this trial. Mm-hmm. I think you're spot on. Even if it's, I don't want to call it a benign question because I don't think any questions that you ask in jury selection are benign in any way. But even if it's a passion question, just by way of example, which is so much more than just the passion, but even in the way that you ask it, whether you give a little story about yourself or you know, you mispronounce things or you make a joke about where you come from, whatever the case may be, really, like Mr. Keenan does so well, it's a litmus test for are they going to accept you? Mm-hmm. So I think you're spot on. And that's all a part of the process in finding a way to still be authentic, but recognizing that when you walk into that courtroom, there are a different set of rules. Mm-hmm. Again, so like kind of mind-blowing in how many things you have to consider. Mm-hmm. So many things to think about. And then, of course, you got to think about your nail polish and pantyhose or no pantyhose.
I know.
You know all the things, in other words.
Yeah.
Too many things.
I wonder, I don't know if I will do this, but I'm wondering, and I might test it out in a focus group, if I would ask in voir dire. Well, actually, we did make one change in our July trial based on feedback in our April trial about objections. We definitely approached that with the jury and said, if a lawyer is objecting, I think it was a which way do you lean question. Do you feel like the person's just doing their job or are they obstructing? And then if the person's not, whatever. And they all said doing your job. So then we took that moving forward in that trial and just did a straight up, if they were not being obnoxious, but if they did something that wasn't, appropriate, we would object so that there was no negative. So we were able to kind of combat it that way. And I wonder if maybe saying something like, if a lawyer gets emotional during closing argument, would you take that out on the client or something? If you knew that was a thing, I don't know. Beautiful.
No. I'm totally in line with you. Out of curiosity, since you made that shift in your July trial, do you do you feel it made a difference? I mean, do you feel, how did it feel?
It felt better. It felt
Okay.
better because, well, I'll always say this. It were two completely different cases, and the jury liked the July case a lot better. But, and what goes into that, a million different things. But I did feel like I wasn't thinking so much about whether or not I would be perceived as overly aggressive if I objected. So that was almost a weight off of my shoulders. So I was like, okay, they have given me permission to object when I feel like it's in the best interest of my client or my case. Therefore, I'm going to do it and not have to think, oh, if I object, did I do 7 objections yet? If that's too many or anything like that, which is something that I kind of would have struggled with before as to whether, is this something important? Do I let it go or not? So I would say it was really.
Cool. And doesn't this also fall in line with what seems to be on Bubba's forefront, which is that they just expect us to be good all the time? And so that kind of falls, right? It falls in line with what their expectation is of us. And even like on one of the things that I really tried to focus on in this last trial was I tend to, I just have to I'm always doing something with my hands, even if I'm sitting there.
Over here like this.
Oh, just like, and I can't, I'm focused, but just being mindful of, because that is, and I think this applies regardless of gender, but just being mindful of the message that you're sending, because they are just totally watching you. Or the nervous, your foot is going back and forth, it's just these little things that they're watching you all the time with the expectation that you really have your crap together. You're not given, there is no leeway. If you've shown up, then you better know what the hell's going on at all times, even in the back of your head. So, which is tough, but also I think a little bit freeing, because I think you're spot on in the sense that understanding that the theory was objections are seen by Bubba as being obstructive. But I really, really think that for us as female lawyers, especially when we're asking for money for pain, that the expectation is, well, I'll give you money, but you better know what's up.
That's I mean, we've kind of touched on this throughout this whole segment today, but I do think there is something not only to being female trial lawyers, but to being female plaintiffs lawyers, asking for money. I mean, you're already, all of us plaintiffs lawyers, men, women, whatever, are all in a hole when we walk into that courtroom because of what we're doing and because of the way society views it, generally speaking, although a lot of focus groups try to tell me, oh, I don't have any negative view about that. I'm like, I don't know, that either you don't have much self-awareness or I don't know what's going on there.
Right.
But 100%. We do. And then on top of it all, it's an area of law that a lot of judges don't know much about. And we're expected to be perfect at it, as, at least from the female perspective. I mean, we're definitely, some of this has become a little bit of war story sharing. And so I apologize to the audience if that's obnoxious, but I just as an example of what this entails is that you can I had male opposing counsel who was totally unprepared. He didn't know what he was doing. He was, you could see it was a Zoom trial. You could see his jeans, under his desk, and it was all disheveled, and they thought he was hilarious and funny. And, and I would not have been able to have that same leeway. So, and that's why we do mention that there's a little bit of a difference between men and women, but definitely as plaintiffs lawyers, it's an area of law. I don't know, what's your bench like, Kari? Do you have a lot of judges who know personal injury or know civil law?
No.
Yeah.
No, I would say, on the spectrum, we're complaining a lot. Most of our judges are former DAs or insurance defense lawyers. And why? Because plaintiff lawyers make good money.
Yeah, you don't want to go on the bench. No thanks.
Right? And it's really hard to get plaintiff lawyers to want to be on the bench. So the reality is we're left with lawyers that are either extremely biased or don't know the law.
Yeah.
And that's why, it's really obvious when you started to see this back in the day, this slew of these anti-reptile motions, when our response is, sorry, this is like black letter law. This is not some sort of witchcraft or Kool-Aid it's not it at all. But these judges, they don't understand foreseeability.
they don't understand the law to begin with. So the defense, they're coming back and saying, well, this is just the law. They're like, oh, I don't know that. So sorry, it's not going to work.
Right. And I'll tell you too that there are definitely some judges that have been dinged, we shall say, because of their such a apparent and abhorrent bias, particularly for certain plaintiffs' firms. So when we have bigger firms that have obviously a much larger volume of cases, then what you see happening is that these judges have such a hatred that they issue these orders that then impact, all the other plaintiff lawyers. And so we really, and I hate to complain about it because I know everybody, just from the bench perspective, there really is a need for judges that are just willing to understand the law, but just be unbiased and follow the law. But that has definitely been a situation here, especially in central Denver, but it's been a situation here in Colorado where you're just, and I don't know how many times I've said this, but you're just craving. I would take a judge, any judge, as long as they were willing to read and follow the law. That's all. You can be mean to me. In fact, kind of makes me the underdog, maybe the jury feels sorry for me. I can take meanness. I really can. But what I want is fair. That's kind of hard. It sounds like it's the same where you're at as well.
It is. And it's very frustrating. And then on top of it, the jury doesn't see that back and forth. And,
That's right.
We had a judge recently who admitted she didn't know what she was doing, but of course not in front of the jury. And it was like, then you're perceived because they have either a vendetta against you, maybe because they don't like your firm or they don't like plaintiffs in general or don't understand the law. And that can, at least for me, speaking personally, that can show up in my questioning when I get back into the courtroom when the jury comes back in. I have a very hard time kind of tamping down that frustration because I know I'm in a losing battle, because no matter what I do, it's going to be against me. And then of course, we huddle and we say we'll go to appeal or whatever, but it's like, it's just, and I hate to say unfair because that sounds so juvenile, but it's not, it's not justice. We want justice, and rule against me. I've said this a million times. Rule against me if I'm wrong. I don't care.
Right.
But if I'm right, that's not right for you.
100%.
Just go with
100%. And we talk a lot about the POV of the judge, and a lot of the discussion when we were developing the course curriculum was talking about judges that have a pretty substantial disdain even for female lawyers, and just how you get around that, maybe how you use that to empower your case in a way that it couldn't before, whatever the case may be. But again, I think it's just recognizing that you need to consider the POV of your judge for all the reasons that you just discussed, and having a discussion about that. We have a judge that my firm has had several cases in front of, and this year there's some sort of bad blood, you shall call it. And that's been a big topic of consideration, just even in terms of presentation. How is that going to come across? Do we know, is it a small enough issue that we're not going to object because of how it looks to the jury versus is it something that we have to for an appeal? All the things, but very important discussion to have, no matter what your case is.
Absolutely. I have a couple of questions before we, a little bit more logistical stuff before we wrap up. So this is not, men are not allowed. Correct.
That's right.
Okay.
That's right. Thus far. And we are, like I said, Laura and I we need to revamp the course. So I'm just going to be honest and say that may change. That's how it was in the 2 years that we offered it. But like I said, we're working on revamping it. And certainly if there's an interest by men to attend this course, then all ears. Absolutely welcome that, for sure.
Folks are listening or who will listen to this recorded, if men in your life are interested, maybe just to understand more what we're dealing with, or to figure out how they can help or whatever, or maybe share some experiences that they have too, that might make it seem like we're not alone in what we're dealing with. All of those things could be helpful. So if people have thoughts on that, please put it in the comments or contact Kari, and as they're revamping the course, they can think about it.
And can I just make a quick comment on that, Jenna, too? Something that, and I know that in our field, we have a lot of solo practitioners or smaller firms, and maybe you've only ever worked with if you're a male and you've only ever worked with male lawyers just within your firm as colleagues, understanding the powerfulness of trying a case with a female too, and the potential power that can hold. But if you genuinely are like, gosh, I just want to learn some things, even just about connecting with my female colleagues, we would love to hear that feedback and to see what the want and need for that is as well.
Yeah, definitely. And then is this a 2-day course?
It was offered as a 2-day course. That's right. We had talked, so in terms of the revamp, we have had discussions about doing more of a seminar versus a course. That is something that we had talked about. So stay tuned on that issue as well.
Okay. All right. And how about homework? What do we need to have prepared for it? Just be who we are. I don't know.
Yeah, I am trying. I think we had some blog reading per usual, but other than that, and no. Aside from that, I know that we asked the attendees to bring a particular case so that we could roundtable all the issues within the context of the curriculum. So, typically, when you come to a college course, you're focusing on one part of the trial. This is where we would have the attendees bring a case, and we could vet it from, stem to sternum in terms of, what are the issues that you're worried about that we can help address within this course. Whether the case is going to trial right then, maybe the case is just starting, whatever the case may be.
Okay, and then it might be a good idea to bring it early on in litigation, but at least when you know who your judge is. So
that's
maybe
right.
One of the things to
100%, great consideration.
Awesome. All right. Well, thank you so much, Kari. And thank you to all of you who joined us live for this week's episode of Fridays with Keenan's Cutting Edge. If you liked the episode, please click that thumbs up button, I don't know, little icon, whatever it is, to feed the YouTube algorithm. And don't forget to subscribe and sign up for alerts so you don't miss an episode. Next week, we will be hearing from Lauren Pillier. And I apologize, Lauren, if I pronounced your last name incorrectly, but I believe that's how it is. She's going to be talking to us about her experience going to truck driving school. This is really neat. It is a topic that Papa Don wanted Lauren to speak about with us, and I've been working her into the schedule for a while now. So I'm excited to hear about it. Papa Don wrote a blog article a while back about attending truck driving school, and it's been something that I toyed around with, but wasn't sure do people really do that? And here next week, we will have somebody who's done it share with us what she learned and whether she believes it's a worthwhile thing to do to help out your trucking cases. So I look forward to learning from Lauren next week with all of you. Have a wonderful weekend, and I'll see you next time.